Okay, so at this time, we ask for our witnesses to come to the hearing table. So remember, that just means that you turn on your camera, you keep yourself muted, but you are coming to the hearing table. And as you can see, that timer is in there. So you can pin that timer to active speaker thumbnail. If you need any assistance to pin the timer, shoot Judiciary staff a text message and we will have someone reach out to you to walk you through that step by step, okay? And it looks like we will be starting today on time. So that is in about 3.5 minutes, we will be starting. And so Jonathan, I'm just gonna flag this for you. You do not need to change it, okay? But right now, we mostly see your ceiling, okay? And the ceiling fan. That's completely up to you. If you'd maybe want to get your computer up higher so then they don't see your ceiling fan, but we just wanted to flag that for you, okay? And it looks like we're going to go on to a 90-second countdown. It looks like we will be starting on time today, for what I can tell. So remember all of the rules that I said before. Keep yourselves muted. You have to stay at the witness table with your cameras on the whole time. These are hot mics when we go into recess. Make sure that you claim your bandwidth. If you have any questions, shoot a text to Judiciary staff. We will reach out to you nice and silently. Make sure you're on vibrate and there's no notifications coming. And if you get locked out, shoot us a text. We will unlock the room for you. And I am going to be going on radio silent from here on out.
make sure that that our volunteer.
I can't hear you, Hank. I can't hear you. This is Zoe.
The House Committee on the Judiciary will come to order. Without objection, the Chair is authorized to declare recesses of the committee at any time. We welcome everyone to this afternoon's hearing on copyright and the Internet in 2020, reactions to the Copyright Office's report on the efficacy of 17 U.S.C. 512 after 2 decades. Before we begin, I would like to remind members that we have established an email address and distribution list dedicated to circulating exhibits, motions, or other written materials that members might want to offer as part of our hearing today. If you would like to submit materials, please send them to the email address that has been previously distributed to your offices, and we will circulate the materials to members and staff as quickly as we can. I would also remind all members that guidance from the Office of Attending Physician states that face coverings are required for all meetings in an enclosed space, such as committee hearings. Everybody attending this hearing is required to follow this guidance, and I will not recognize members to speak who are not in compliance with these rules. If you do not wish to put on a mask, you have the option to participate in this hearing remotely. Finally, I would ask all members, both those in person and those appearing remotely, to mute your microphones when you are not speaking. This will help prevent feedback and other technical issues. You may unmute yourself at any time that you seek recognition. I will now recognize myself for an opening statement. Today's hearing will examine whether a key provision of copyright law that guides how copyright and parts of the Internet interact with each other has fared well in today's digital age. This provision, Section 512 of Title 17, was enacted in 1998 as part of the Digital Millennium Copyright Act. Back then, Internet activity was in its nascency. Many of the online platforms that we consider universal today were only a few years old or had yet to be formed. eBay had been around for just 3 years, Google was founded that same year, and Facebook's birth was still 6 years away. With the burgeoning ways for people to share and distribute content through the Internet, in enacting Section 512, Congress sought to balance 2 goals. On the one hand, promoting the growth and innovation of online networks, and on the other hand, protecting intellectual property rights and that incentive system for promoting the creation of new expressive works. At the heart of Section 512 is the notice and takedown system. Broadly, under notice and takedown, a copyright owner can send a notice to an online service provider when a third party is used allegedly infringing material through or on the provider's services. The online service provider must then take that material down. If the online service provider complies with the notice and takedown process, its liability for infringement is limited. More than 20 years have passed since Section 512's enactment, and it would be an understatement to say that the Internet has changed rapidly during that time. The Internet has gotten faster and more accessible, and the number of ways to share and view copyrighted content has increased dramatically. In tandem with these increases, we have also seen a dramatic increase in the volume of infringing materials being shared and viewed online. Our copyright laws have to keep up. Today, we seek perspectives on whether Section 512 is working efficiently and effectively for this new Internet landscape, and whether the balance that Congress sought in 1998 is still being achieved in 2020. Our discussion is guided by the Copyright Office's recent report that studied this very question. I want to applaud the Copyright Office for the care and diligence with which it undertook this study. Their work began 2 Congresses ago, when this committee requested that it study Section 512 in light of all the changes the Internet had undergone. The office's view is exhaustive. They reviewed more than 90,000 comments, held public roundtables in Washington, New York, and San Francisco, and conducted an extensive review of case law on this issue. Turning to the report's substance, the office concluded that the balance that Congress originally sought in enacting Section 512 is now askew. The office found that online service providers and user groups were generally satisfied with Section 512's operation, but copyright owners typically disagreed, finding Section 512 ineffective in the face of the current scale of infringement. To address this imbalance, the Copyright Office includes recommendations for areas that Congress may wish to fine-tune or clarify, as well as voluntary measures that the office considers valuable for increasing the efficacy of Section 512. To better understand the Copyright Office's recommendations, staff of the committee held a series of 11 listening sessions over the summer, hearing directly from over 90 panelists including creators and artists, and representatives of public interest groups, libraries, online service providers, internet service providers, legal practitioners, and the sports, live entertainment, music, film, television, software, news, print, and photography industries. I want to thank the many people who participated and also all those who followed up with written statements for this hearing. Without objection, I will place those statements into the record. Here with us today, we have 6 witnesses to provide the committee with a representative set of reactions to the Copyright Office's report and recommendations, and ultimate conclusion that Section 512 is out of balance. Today's witnesses reflect the diverse interests at stake when copyright and the internet intersect, and their perspectives are invaluable. A lot has changed since 1998, and today's dialogue will mark an important step forward in ensuring that our copyright laws are keeping pace with reality. I thank our witnesses for joining us today, and I look forward to their testimony. I now recognize the ranking member of the Judiciary Committee, the gentleman from Ohio, Mr. Jordan, for his opening statement.
Thank you, Mr. Chairman. I, too, want to thank our witnesses for being here today. The Digital Millennium Copyright Act, or DMCA, was a landmark piece of legislation when it was enacted in 1998. It provided needed certainty for stakeholders in the copyright system and a framework that contributed to more than 2 decades of explosive growth and innovation online. As important as the DMCA was and continues to be, 2 decades is an eternity when it comes to the internet, as you expressed in your opening comments as well. Many of the ways in which Americans access content online today had not been invented or developed when the DMCA was enacted. For example, YouTube, Facebook, Twitter, Pandora, Spotify, and Hulu all started years after this legislation was passed 2 decades ago. Over the past decade, Congress has begun to look more closely at how the copyright system and the DMCA is interacting with this shifting landscape online. The stakes are critical to our economy, to our country. The creative industry contributes hundreds of billions of dollars to our economy each year and employs millions of Americans. Today, creative content is primarily produced and distributed and consumed digitally over the internet. As a result, writers, musicians, filmmakers, photographers, and other artists depend on online service providers to reach their audiences and earn a living. They're not alone. Creative works also represent the talents and skills of technicians, engineers, researchers, editors, and countless others, all of whom depend on the economic success of those creative works online. This is why the DMCA is important, and particularly Section 512. Section 512 protects online service providers, but requires them to implement procedures intended to allow copyright holders to protect and control their creative work on those services. Over the past decade, though, many stakeholders have come to Congress to alert us that they feel that this section is not working as it was intended. The problem facing many creators today is not a few dozen fake CDs or DVDs sold on the street, but instead illegal uploads of multiple websites where they are accessed or downloaded millions of times. The economic harm of millions of unauthorized downloads to a creator is obvious, since each download is potentially a lost sale. But the true impact may be much wider. By some estimates, online piracy costs our economy around $30 billion a year and affects everyone in the creative industry. For their part, service providers must advance the purpose of Section 512 to protect copyrighted works online in order to benefit from its safe harbors. But they must also balance the rights of users, including freedom of expression. That can be a difficult task, particularly considering the vast amount of content uploaded to the internet each and every day. For example, YouTube alone sees 500 hours of video uploaded every minute, every single minute. Fortunately, technology exists to help in that task, and additional advancements in years to come will help further. While the government should not become more involved than necessary, we must continue to monitor this area of law and play a constructive role by making any necessary adjustments to Section 512 framework and by incentivizing innovation to better address online copyright infringement. The system must do a better job of protecting the rights of copyright holders while balancing the interests of the public. This is why I'm pleased the committee has convened this hearing and exploring these issues that are vital to our economy, to our country. I want to thank all our witnesses for participating, as I said earlier, and assisting us in this hearing. And Mr. Chairman, I would yield back.
Thank you, Mr. Jordan. Without objection. Thank you, Mr. Jordan. Without objection, all other opening statements will be included in the record. I will now introduce today's witnesses. Jeffrey Sedlick has been a professional advertising photographer in Pasadena, California for 35 years. He has been a professor at the Art Center College of Design for 25 years, teaching courses on copyright law and licensing. Additionally, as the president of the nonprofit Plus Coalition, he managed the successful development of multiple standard technical measures for visual arts. Meredith Rose is a policy counsel at Public Knowledge, where she specializes in technology, telecommunications, and intellectual property policy. Previously, she worked on consumer policy issues at the Federal Communications Commission, the Transatlantic Consumer Dialogue, and Knowledge Ecology International. Ms. Rose received her bachelor's degree and law degree from the University of Chicago. Morgan Kibbe is a classical pianist, cellist, and vocalist. In addition, as a writer, producer, and performer, she has both created solo works and works produced in collaboration with many other artists, which have garnered critical acclaim and award nominations. More recently, she has scored projects for several online streaming services and for films in competition at major film festivals. Jonathan Band is counsel for the Library Copyright Alliance. He is also an adjunct professor at the Georgetown University Law Center, has written extensively on intellectual property and the internet, and has many years' experience in private practice. He is a graduate of Harvard College and Yale Law School. Matt Shears is president of the Computer and Communications Industry Association, where he directs its advocacy on behalf of leading internet communications and technology companies. He joined CCIA from private practice in 2005. For 10 years, he has served as an adjunct professor, teaching both intellectual property and internet law at Georgetown University and American University Washington College of Law. He's a graduate of Duke and the University of Virginia School of Law. Tarika Carrington is Vice President, Legal Policy and Copyright Counsel at the Copyright Alliance, an organization dedicated to protecting the rights of creators and advocating policies that promote the value of copyright. Ms. Carrington is also an adjunct professor at George Mason University School of Law. She's a graduate of the University of North Carolina, Chapel Hill, and George Mason University School of Law. We welcome all of our distinguished witnesses, and we thank them for their participation. Now, if you would please rise, I will begin by swearing you in. Do you swear or affirm under penalty of perjury that the testimony you're about to give is true and correct to the best of your knowledge, information, and belief? So help you God. Let the record show the witnesses answered in the affirmative. Thank you, and you may be seated. Please note that each of your written statements will be entered into the record in its entirety. Accordingly, I ask that you summarize your testimony in 5 minutes. To help you stay within that time, there is a timer on your screen. When the light switches from green to yellow, you have 1 minute to conclude your testimony. When the light turns red, it signals your 5 minutes have expired. Mr. Sedlick, you may begin.
Chairman Nadler, Ranking Member Jordan, and other members of the committee, thank you for the opportunity to testify today on Section 512 of the DMCA. My name is Jeffrey Sedlick. I've been a professional photographer for 35 years, and I am the author and owner of hundreds of thousands of copyrighted photographs. I'm also the president of the Plus Coalition, a global nonprofit organization in which diverse stakeholders from 140 countries have collaborated to develop standard technical measures to ensure that the public can access and understand rights information for visual works. The Plus standard technical measures have adopters including Google, Yahoo, Adobe, and millions of creators and users throughout the world. I make a living creating and licensing photographs to appear in all manner of media. The photographs that I create are protected under US copyright law, at least in theory. In reality, my photographs receive very little protection because of the rampant infringement of my work that is knowingly permitted by online service providers on their platforms and websites. Instead of using readily available technologies to identify and mitigate copyright infringement, service providers hide in the safe harbor of 512, ignoring illegal activity, allowing infringers to infringe, exploit, and monetize my work with impunity, unless and until I submit a DMCA takedown notice. As a result, I'm forced to dedicate my very limited time to searching for infringements, making screenshots to document the infringing material, collecting hundreds or thousands of infringement URLs, combing through obscure OSP menus to find DMCA agent information, drafting and submitting takedown notices, and responding to inane, unnecessary, superfluous follow-up questions from service providers. Once the infringement's taken down, it will inevitably return, often the same day, because service providers uniformly fail to effectively implement and enforce repeat infringer policies. Enforcing my rights under the DMCA is an impossible task, not just for me, but for my fellow creators across this nation. Most visual artists operate as micro businesses, often with no employees. Like other creators, in order to feed my family, I must generate revenue by creating and licensing new works continuously. But in attempting to license my works, I find that I'm forced to compete with hundreds of thousands of unlicensed, unpaid, infringing uses of my works on service providers, platforms, and websites. If I do not enforce my copyrights, my work has no value and my business is not sustainable. But if I dedicate the time and effort necessary to identify and repeatedly enforce my copyrights with takedown notices, I have no time left to create new works. This is an untenable situation, one that I and innumerable other visual artists and small businesses are forced to confront on a daily basis. If my takedown notice is met with a counter notice, 512 allows me just 10 days in which to interview and retain an attorney and file a complaint in federal court, or the infringement will be back online. If I do not have a copyright registration for the photograph in question, I face the prospect of paying the Copyright Office more than 10 times the normal registration fee in order to expedite processing of my application under the special handling procedures, with no guarantee that the office will be able to actually process and approve my registration within 10 days. Certainly, this is not the effective, balanced system envisioned by Congress when it enacted the DMCA. The fact that it takes millions of takedown notices, the fact that millions of takedown notices are issued each day is not a sign of success. It's a sign of an unbalanced system under strain and on the verge of failure, if not beyond. I thank the Copyright Office for their years of great work on the 512 report. I agree with and support the recommendations of the Copyright Office. In my written testimony, I present 13 additional recommended revisions. I make these suggestions on behalf of the American Photographic Artists, the American Society for Collective Rights Licensing, the American Society of Media Photographers, the Digital Media Licensing Association, the Graphic Artists Guild, the National Press Photographers Association, the North American Nature Photographers Association, the PLUS Coalition, and the Professional Photographers of America. In closing, I again thank the committee for your efforts to improve the Copyright Act and for the opportunity to share my experience and suggestions in my testimony today.
Thank you, Ms. Rose.
Chairman Nadler, Ranking Member Jordan, members of the committee, thank you for inviting me to testify today on this important topic. More than 229 million American adults use the internet each day. It is not just a delivery mechanism for copyrighted content. It is the lifeline by which they work, worship, connect with their families and communities, seek and receive healthcare, stay informed, organize, debate, and exercise political speech every single day. And yet, despite the scale and importance of this constituency, they are conspicuously absent from the Copyright Office's Section 512 report, absent from the oversight mechanisms governing their speech, and absent from the debate on Capitol Hill. This is the constituency on whose behalf I speak today, the forgotten 229 million users in this debate. My written testimony gets into some detail, but I wanted to use my time to touch on three major issues. Section 512's outdated stance on broadband access, the powerful nature and attendant abuse of takedown notices, and the difficult realities of automated enforcement. First, Section 512 governs the way in which I am speaking to you right now, through a broadband connection. The Supreme Court has held that cutting individuals off, even after being convicted for child sex offenses, raises grave constitutional concerns. Therefore, we cannot, as a society, accept a law which allows unvetted accusations from private parties of a civil offense to disconnect an entire household from modern society. Yet lower courts have interpreted Section 512 to mean exactly that ISPs must shut off households' internet access upon receiving unproven allegations of copyright infringement. A bright spot of bipartisanship currently is the push to expand broadband access, represented by no fewer than 30 bills currently before Congress in both chambers and across the political spectrum. Yet major content companies insist that this power they wield is not only appropriate, but insufficient for their purposes. Historical context is important. When the DMCA was passed in 1998, ISPs were software providers that operated over the telephone network. As a user, if your AOL account was terminated, You instead subscribe to any of the dozens of AOL competitors. In 2020, ISPs such as Comcast or Verizon controlled both the software and physical connection into your home. For the more than 100 million Americans living in homes serviced by only one broadband provider, an account termination means losing access to the internet in its entirety. Shifting ISP business models, as well as the rising importance of broadband to modern life, have rendered this punishment wildly disproportionate to the alleged offense. Second, we must acknowledge the systemic problem of bad DMCA notices and their impact on everyday speech. A DMCA takedown has a power which is unparalleled in the online ecosystem. It can erase speech from the internet for up to 2 weeks. Takedowns are rarely contested, and there's no meaningful oversight of these notices or disincentive against abuse. The result is a long and thoroughly documented history of weaponization, with experts estimating that nearly 1/3 of notices are problematic. Although bad notices stem from everything from algorithmic defects to deliberate abuse, their aggregate impact is undeniable. Senders can use takedowns to censor legitimate content. Incomplete or error-filled notices can make it impossible for platforms to identify the works involved, and search and notice robots can and have disrupted live streams and news broadcasts. Some stakeholders, however, still insist that they need faster takedowns with fewer user safeguards and greater potential liability for any platform that attempts to filter out defective or malicious notices. Finally, we must understand the limits of private, technologically based enforcement solutions. These often sound good in theory, but the reality is far messier. Because they operate automatically, these algorithms are prone to removing speech that is otherwise political, educational, or newsworthy. And policymakers must grapple with what users and artists alike have understood for ages, that the balance of equities in practice is not determined by the law, but by the financial incentives, design choices, and technological limitations of those who design the algorithms. We are at a historic inflection point, politically, economically, and socially. On the streets, at the polls, and in their homes, Americans are online. We are registering to vote, testifying before Congress, organizing political action, and attending weddings and funerals all online. We are debating and documenting our lives, our surroundings, and our realities across ideological and geographic divides. The internet is how we bear witness. It is how the work of community activists and organizers is amplified, and how we see ourselves and how we are seen by the eyes of the world. If we are to strike any sort of new balance, it must keep the needs of 229 million voices and their ability to speak freely at the front of mind. Thank you, and I look forward to your questions.
Thank you, Mr. Kibbe.
Chairman Nadler, Ranking Member Jordan, and members of the committee, thank you for inviting me to talk about the Copyright Office's report on Section 512 of the DMCA. I appreciate the inclusion, as the heart of this discussion is not just legal jargon, market analysis, or political calculations. It is the real and profound effects Section 512's failings have on people like myself. The Copyright Office's report is confirmation of what creators and copyright owners have said for years about Section 512. It's just not working, but that statement is too benign. It is undermining creativity and, more alarmingly, systemically undercutting our next generation of artists. It is jeopardizing livelihoods of working class musicians and obliterating healthy monetary velocity in our creative community. It is rewarding unscrupulous services that deal in the unauthorized trade and use of our works, and it is fundamentally sabotaging the legitimate online marketplace that we all rely on and that Congress envisioned. As a self-employed creator, I've dedicated my life to my craft. Through decades of study, collaborating and touring with artists like M83 and Lady Gaga, unrelenting deadlines, scoring for film and TV, promoting my work, and navigating a music industry in constant structural flux, I have methodically committed myself to building my career and making art that moves people. It's no secret that the creative life can sometimes have little promise beyond that exchange, and so it becomes my very dedication that is robbed of agency when there is a clear expectation that I now also spend hours looking for violations of my work. The popular mantra of working 10,000 hours to achieve mastery should apply to my craft, not to the protection of my content. I can't afford to spend even a fraction of this time monitoring and noticing infringements, as it's time spent away from my work, which is creating. So the truth is, I just don't do it. Trying to enforce my work within Section 512's notice and takedown system is a futile endeavor, as monitoring for infringements and sending notices does not curtail unauthorized works from popping up. It's like digging in the sand at high tide. And this problem is existential. When NASA artists don't see a viable path forward in a career already laden with inherent challenges, some simply won't continue. Perpetuating an ineffective enforcement system means fewer creative works, shrinking cultural identity, and fewer creators who cannot afford to press on. The intention of the DMCA's drafters was to decrease infringement, not to decrease production of creative works. I've heard claims that implementing a system that takes down infringing copies promotes censorship. I would counter that stripping creators like myself of their fundamental rights, livelihood, and contributions is the true censorship. I'm frustrated that the existing system devalues us and in turn weakens our very culture. I recognize that creative fields occupy an odd place in the consciousness of priorities, especially in this challenging year, but culture is art defined by a systemic empowerment of creators. How many artistic futures will we sacrifice because we can't come together to get this right? Unfortunately, service providers have no desire to shift our current paradigm. Why? Because the status quo under Section 512 is simply more lucrative. Commercial works like mine drive online traffic and in turn generate advertised revenue. In a system that allows for perpetual removal of works after the fact, instead of requiring proactive licensing, there's simply no incentive to secure licenses or stop infringement. There's financial incentive to do the exact opposite. This is a flawed system established by Section 512, and online services must be required to do their part to resolve it. The Copyright Office report understood this and provided guidelines, including clarifying who actually qualifies for the safe harbor, strengthening policies on repeat infringers, and requiring more action by services. So while my area of expertise is art, theirs is technology. They surely can create algorithms to help us curtail the flow of infringing works on their platforms. Some artists can afford to allow their works to be distributed freely across these platforms, seeing it as promotion, perhaps a mean to go viral. But even as a musician lucky to make a living doing what I love, every dollar counts. And in the shadow of an industry transformed with peer-to-peer sharing and the post-COVID-19 obliteration of touring, our works on these platforms generate income. They're not a loss leader for other revenue streams. Undoubtedly, technology can be used to distinguish between artists who are okay with their unauthorized works on these platforms and those who aren't. There are algorithms, there are already programs in place to monitor and filter unauthorized content. And so I have to ask, with the more than capable minds of tech, how hard can it be to present users with questions to confirm that they have authorization to upload content? I'm grateful that Congress recognizes we are attempting to fix and is pushing service providers to participate in finding solutions. As the Copyright Office put it, the degree and breadth of cooperation between OSPs and right holders that was anticipated in 1998 has not come to full fruition. That's absolutely true, and it's a shame because that's what was intended, a balance of interests and a balance of responsibility. So we're hopeful that our tech partners will join us to finally achieve a fair and effective DMC for all. Thank you so much.
Mr. Band.
Chairman Nadler, Ranking Member Jordan, members of the committee. I'm grateful for this opportunity to provide the views of libraries on the Copyright Office Section 512 report. I will briefly discuss the importance of Section 512 safe harbors to U.S. libraries. I will then make 3 points about the 512 report. First, libraries agree with the report that Congress should not consider foreign approaches to online infringement such as notice and stay down. Second, libraries agree with the Copyright Office that abusive takedown notices are a serious problem requiring congressional attention. Third, libraries disagree with the report's conclusion that the balance Congress established in Section 512 is askew. To the contrary, the DMCA is working just as Congress intended. Libraries provide a variety of internet-related services. As a practical matter, libraries can provide these services only because of the DMCA's safe harbors limit libraries' liability for their users' online activities. In particular, the mere conduit safe harbor in Section 512A enables libraries to provide internet access to their users. Libraries are the only source for free internet access for most Americans. Also, they often are the only source for reliable broadband in rural areas. Even now during the pandemic, when many libraries are closed, they've left their Wi-Fi networks on, enabling users to access the internet from parking lots. The Section 512A safe harbor allows libraries to provide internet access without the threat of large copyright damages for infringing user activity. Turning to the Section 512 report, we agree with its conclusion that Congress should not adopt a notice and stay down regime. The filtering necessary to implement notice and stay down would have many false positives and would not accommodate fair use. This would be a serious problem in the area of political speech. A filter could wrongly block a campaign ad on the eve of an election. We also agree with the office that the issue of abusive takedown notices is serious and requires congressional attention. We urge the committee to explore possible solutions to the misuse of the notice and takedown system. Perhaps the Federal Trade Commission should be provided with additional tools to address this issue. While the 512 report got many things right, it got one very important thing wrong. It concluded that the balance Congress intended to strike in Section 512 is askew. It reached this incorrect conclusion because it did not appreciate the interconnected structure of the DMCA. Contrary to the suggestion of some that the grand bargain of the DMCA is to be found within Section 512 itself, the DMCA's grand bargain was the adoption of the Section 512 safe harbors in exchange for the enactment of the prohibition on the circumvention of technological protection measures in Section 1201. As the committee studies this issue, it must always bear in mind that Section 1201, dealing with TPMs, and Section 512, dealing with safe harbors, were enacted together to create a balanced approach to copyright infringement in the internet environment. Thus, the effectiveness and fairness of the safe harbor system should not be considered in isolation, but in relation to the effectiveness and fairness of the anti-circumvention provisions. Unfortunately, the Copyright Office conducted two separate studies, one of 512 and the other of 1201. The office looked at each section in isolation and thus did not consider whether the overall balance Congress struck in 1998 was still intact. The committee should examine copyright in the internet through a wide lens. The question is not whether some individuals or even some industries are disadvantaged by online infringement and could be benefited by imposing greater burdens on service providers through amendments to Section 512. Rather, the question should be whether the goals of the copyright system, promoting the creation and distribution of works for the public benefit, would be best served by recalibrating the balance established in the DMCA. We live in a golden age of content creation and distribution. The DMCA is in large measure responsible for this golden age. It is a shining example of enlightened legislation for the public good. We disturb it at our peril. Thank you very much.
Thank you, Mr. Shears.
Thank you, Chairman Adler, Ranking Member Jordan, members of the committee. My name is Matt Shears. I am president of the Computer and Communications Industry Association, which represents many of the world's leading internet communications and technology firms. Thanks for the opportunity to discuss Section 512 today. Section 512 represents an enduring compromise which requires service providers to respond expeditiously to complaints from rights holders in exchange for certain liability limitations. In return, rights holders get rapid extrajudicial relief from reported acts of alleged infringement. This gives critical legal certainty to the digital economy, which accounted for 6.9% of US GDP as early as 2017. CCIA members and thousands of other services, websites, and apps utilize these protections. An even larger number of small businesses and independent creators utilize those 512 dependent services to engage in communications, creativity, commerce, and campaigning, as well as accomplishing daily activities, a need that's particularly acute when a pandemic compels social distancing in so many contexts, like this hearing. Some companies voluntarily invest in additional service-specific tools to mitigate infringement and help monetize content. Section 512 makes this voluntary private sector cooperation possible. It's sometimes called DMCA Plus because these service-specific systems exceed Section 512's requirements. DMCA Plus systems offer speed and efficiency, but they are costly. They're site and often media specific, and they do struggle with false positives. That's important because the more powerful the tool, the bigger the risk of misuse against users. So companies have to balance these concerns when deploying DMCA Plus tools. The Copyright Office's report omits any consideration of this, and as you've already heard, takes a very isolated view that largely overlooks users as a constituency in DMCA policymaking. And this, despite coming right on the heels of a Wall Street Journal investigation that uncovered serious cases of misuse by claimed rights holders who are actually attempting to suppress lawful speech. Now, to be fair, the office subsequently acknowledged these concerns, but the omission of these well-documented problems in the report is noticeable. As my testimony describes in greater detail, political campaigns have been targeted with Section 512 misuse for over a decade, and even in this cycle. As an association executive, I frequently hear from industry about these problems. So any 512 amendments need to address these issues. But speaking more broadly, amending Section 512 is not the low-hanging fruit. The twin goals of ensuring that creators are compensated and that the public can access creative work is better served by promoting more legitimate channels for the distribution of copyrighted works and enforcing existing law against offshore actors who aren't complying with Section 512 in the first place. So I would say one more effective way to prevent infringement is to enforce our existing laws against offshore actors who don't view the DMCA as a constraint, and then separately to ensure that consumers have options to lawfully access content when they want it and where they want it. We know that piracy rates fall when consumers have multiple lawful means of getting access to digital media. And CCIA members play an increasingly important role here, enabling creators of all walks to reach a worldwide audience online. Digital services are increasingly the leading means by which creators can monetize their works, and they're playing a critical role in distributing creative content in the pandemic. Legislative efforts focused on fostering this kind of digital commerce would probably bear more fruit than implementing the report's uncertain recommendations. Thank you. I appreciate it and look forward to any questions you have.
Thank you, Ms. Carrington.
Good afternoon, Chairman Nadler, Ranking Member Jordan, and members of the committee, and thank you for the opportunity to testify today. I am Terica Carrington, VP Legal Policy and Copyright Counsel at the Copyright Alliance, an organization dedicated to advocating policies that promote and preserve the value of copyright and to protecting the rights of creators and innovators, including the more than 13,000 organizations and 1.8 million individual creators whose interests we represent. After nearly 5 years of thoughtful and comprehensive deliberation by the Copyright Office, earlier this year, the office issued its long-awaited Section 512 report, which concludes that Section 512 is unbalanced and not working as Congress intended. While online service providers, or OSPs, are routinely shielded from liability under the DMCA, the problem of online piracy has grown enormously, leaving copyright owners to shoulder the burden alone. Today, I expect this committee will hear from representatives of OSPs who will say that Section 512 is working just fine. This only reinforces our point. Where the OSPs are pleased with Section 512 and the copyright community is not, it is clear that the appropriate balance has not been achieved. I want to focus my time on 3 issues of concerns that highlight this imbalance. Number 1, the intent of the notice and takedown process was to give copyright owners a faster alternative to filing for a temporary restraining order in light of the speed at which infringement can occur online. Today, vastly increased internet speeds and capabilities have left copyright owners virtually no opportunity to prevent mass infringement. The notice and takedown process does not work well for any size or type of copyright owner, even when automated technologies are used. The number of takedown notices sent is staggering and steadily increasing. The office's report recognizes the frustrations related to the constant game of whack-a-mole faced by creators simply trying to enforce their rights. For example, the report details how the Recording Industry Association of America sent over 175 million takedown notices in the span of 3 years, yet continues to see those works show up again and again. Make no mistake, the large number of notices is not a measure of success. It is an indicator of a system-wide failure. The consensus from our individual creator membership is that online infringement has reached a point where, without access to effective tools, they are unable to protect their work. The office's report states that a system that fails to provide adequate protection of creators' rights of all sizes ultimately fails to carry out congressional intent regarding Section 512 as well as the overall purpose of copyright law. We agree. Number 2, one of the most significant problems with Section 512 stems from incorrect court interpretations and applications of the statutory text, particularly those regarding red flag knowledge and willful blindness. Various courts' interpretation of the red flag standard is so restrictive that it has basically eliminated the careful balance that Congress intended and has effectively written the red flag knowledge standard out of the statute. Some courts have also incorrectly applied the concept of willful blindness, allowing OSPs to benefit from safe harbor protection despite turning a blind eye to infringement. Third, I'll address repeat infringer policies. These policies are essential to maintaining the strong incentives for OSPs to prevent their services from becoming safe havens or conduits for known repeat infringers. The problem is not in the legal framework drafted by Congress, but instead in how OSPs choose to implement these policies. OSPs and copyright owners, with the assistance of government, need to work together to ensure that repeat infringer policies are effective and being implemented as intended. Through such cooperation, OSPs should be able to adopt more acceptable repeat infringer policies. There is no silver bullet solution to fixing what ails Section 512. Instead, we must consider a host of different options, including implementing standard technical measures, developing private sector voluntary agreements, enacting the CASE Act and legislation to harmonize criminal penalties for infringement, and amending the statute to clarify the knowledge standards and overturn erroneous case law. We applaud the office for calling attention to areas of imbalance related to Section 512 and how overly expansive or narrow interpretations of the statute have aided in skewing the balance that Congress intended. The copyright community stands ready to work with this committee, the Copyright Office, and other stakeholders to reduce today's rampant online piracy in a way that takes into account the interests of all stakeholders involved. Thank you again for the opportunity to testify at this hearing, and I'm happy to answer any questions.
Thank you very much. We'll now proceed under the 5-minute rule with questions. I will recognize myself for 5 minutes. One of the most striking changes between the early days of Section 512 and now is the sheer volume of takedown notices that the biggest platforms now receive. It's orders of magnitude larger than 20 years ago, with the number reaching to the hundreds of millions, getting closer to 1 billion in some cases. To me, this volume simply does not seem like the hallmark of an efficient, well-functioning system. Yet I know opinions on what this means are divided. Ms. Carrington, can you please identify whether you believe this volume is a sign of success or failure, and briefly explain why?
Yes, certainly. As you stated, I believe that a vast number of takedown notices that are being sent are an indication of a system-wide failure. They represent a lack of balance that Congress intended. Section 512 is in no way intended to be simply a notice and takedown framework. The notice and takedown framework is one part of Section 512, but there are a number of other responsibilities that OSPs are supposed to be sharing with creators. And so when we see numbers such as the Google Transparency Report showing, I believe, 75 million takedown notices or 75 billion takedown notices, that is a clear indication of a failure. It's showing that creators are continuing to use their time over and over again to send these notices and yet continue to not see any actual practical effect on the rampant piracy that exists online today.
And what do you think we can do about that?
Well, I think that there are a number of solutions. I think the issues with Section 512, we have reached a point at this point where there's not going to be any one simple fix. So we're going to need to do a number of different things, which are going to include, for one, implementing standard technical measures, making sure that OSPs have some incentive to actually come to the table and negotiate and actually implement those measures. To date, they do not have any incentive to do so. They are very comfortable with the status quo because the status quo allows them to operate in ways that are easier for them, but much more detrimental to the copyright community. In addition, I think other voluntary measures need to be implemented. In addition, I think passing the CASE Act would be a huge step in the way of enabling copyright owners as well as users to have an alternative to figuring out these disputes outside of the Section 512 framework. And then finally, amending the statute to clarify the knowledge standards and overturn erroneous case laws will go a long way in restoring the balance that Congress intended.
Thank you, Ms. Kibbe. Thank you for being here today and sharing the perspective of someone trying to make a living from their creative work. Your acknowledgement that you do not really have the time to monitor for unauthorized uses of your work online is both illuminating and troubling. Is this a common situation for others you know working in the creative industries? And more importantly, what is something we could do in Congress to help make it more realistic for you to obtain a fair return on your work when it's used on the internet?
Yes, I mean it's just virtually impossible to spend any amount of time, even with the backing of a large management company, which I'm very lucky to be a part of or to work with. Um, as we all know, being self-employed, it requires you kind of working mentally 24/7. So I kind of gave up. There's just no way, because the moment that I send any kind of notice to get something taken down, it immediately pops just right back up again. I actually just found a video literally 5 days ago on YouTube where someone was using a song of mine that I put out years ago, but the title of the video was actually official music video for this particular song. And not only are they infringing my rights in terms of it being my song that they're using, but they're actually they're taking away the aesthetic of the art that I'm trying to create and misrepresenting me. I think that it seems pretty obvious that there are some basic questions that can be asked for people that are uploading content that we can all agree on would just streamline a process so that we don't get into the nitty gritty. I think that seems to be, to me, a very black and white series of questions that we could at least start with as something to discuss and agree on.
Okay. In my remaining time, Mr. Sedlick, I know you have experience trying to develop standards that would help visual artists, but it seems like success has been difficult and slow. Are there steps that Congress could take to help encourage the development and adoption of more standard technical measures?
Yes. Our model at the Plus Coalition was to bring together all stakeholders into a group in which we set all of our baggage aside and leave all other issues at the door and just talk about how to communicate rights information accurately and effectively. Congress could help by enabling a system that would allow the different stakeholder groups to recognize STMs once, or access and recognize STMs once they are developed. The technology is readily available for a means to communicate rights information, for the identification of works, and for all systems to be able to be searched, to be able to find the rights information for work before that work is posted. And the missing piece is education and the ability to identify the STMs.
Thank you very much. My time has expired. Ms. Roby.
Thank you, Mr. Chairman. And I want to thank all of the witnesses for being with us here today. So thank you so much for your time. The Copyright Office's report, the product of many years of review and submissions from hundreds of stakeholders, concluded that the balance between copyright holders and platforms has been tilted askew. Quote, fails to provide adequate protection of creators' rights and fails to carry out congressional intent regarding Section 512, as well as the overall purpose of copyright law. The DMCA is over 20 years old. Google had just been founded the month before the law was signed, and there was no YouTube, Twitter, Facebook, TikTok, and many other websites and platforms that we use today. At the bare minimum, it seems like we should be looking at ways to bring this law into the 21st century to address the current internet, not one of 1998. I just want to say to each of you, I appreciate very much your written testimony and your oral testimony here today to lay out for us the most important of the Copyright Office's suggestions for reform so that we can ensure that the DMCA is working for all stakeholders. Last year, I had the opportunity to travel to California to tour several movie and TV studios. And one of the most eye-opening experience I had was when I saw the Pirate Living Room demonstration. This demonstration showed how easy it was for people to access pirated material online and how much of that material was infected with malicious software and viruses. The vast majority of websites that offer pirated material are large criminal organizations. However, under current law, if the material is being offered in a streaming format, the operator of that website is only able to be charged with a misdemeanor. In contrast, if the same material is being offered in a downloadable form, the operator can be charged with a felony. This is commonly referred to as the felony streaming loophole. As more content becomes available online through streaming services, so too does the amount of pirated material. As the chairman mentioned, the ranking member mentioned, the U.S. Chamber of Commerce estimated that commercial scale piracy drains a minimum of $29 billion from the legitimate American economy each year. In my home state of Alabama, the motion picture and television industry is responsible for more than 10,000 jobs and 387 million total wages in our state. The music industry contributes $636 million to the GDP and supports more than 14,000 jobs. These industries benefit small businesses such as florists and restaurants, salons, caterers, hotels, and other hospitality businesses that benefit the filming of a movie or the recording of a song. When copyrighted materials get pirated, it hurts all of these small businesses. Earlier this year, the Senate conducted several series of roundtables with stakeholders from across the spectrum, including several of our witnesses here today, to close the felony streaming loophole. And I was extremely pleased that as a result of very hard work by everyone involved, there was negotiated draft text and report language that was agreed to by the stakeholders involved. I have been working with several of my colleagues on the House side to move this negotiated draft legislation forward, and I'm hopeful that we can get it done by the end of the year. And so to confirm with our witnesses who directly participated or were represented in these negotiations, Ms. Carrington, Ms. Rose, Mr. Van, and Mr. Shears, you are supportive or at least neutral on this negotiated language. And each of you, please answer.
Yes, that's correct.
Yes, that is correct.
Yes, that's right.
That's correct.
Well, I appreciate it very much, and I look forward to continuing to work with you on this very important issue. And again, I can't thank you enough for your written testimony, but also your oral testimony here today to talk about this very serious topic. Thank you so much. I yield back.
Gentlewoman yields back. The chair recognizes Ms. Lofgren for 5 minutes.
Thanks very much. This is a very useful and interesting hearing. There's actually just a handful of us on the committee that were members of the committee when we wrote the DMCA, and I'm one of them. And I recall what we were trying to achieve at that time. It's not always what people describe today, but we did the best we could. And what we wanted to do was to make the possibility of growth in the technology sector while protecting the rights of creators. And that's kind of what we hope to do. We had some concerns at the time, I did, because, you know, Ms. Kibbe, you're not in favor of somebody abusing the notice and takedown. I mean, you just want to get paid for your work. But there are some who abuse it. For example, cited in some of the testimony, the Church of Scientology doing takedown notices to prevent criticism of their activity. That's not what you're about. You want to get paid for your work. So I was concerned at the time that the tech sector would really have no motivation to stand up for the First Amendment. They would want to take down to protect themselves. And in fact, that has occurred, although it hasn't. There are problems in terms of the volume. Obviously, if you take a look at what's happened since 1998, because of streaming services like Netflix, the MPA reported global industry revenues of more than $100 billion for the first time ever in 2019. The music industry, U.S. revenues for recorded music reached over $11 billion in 2019, the fourth straight year of double-digit growth. Video games, global revenues are way up, over 150 billion globally in 2019 and higher, I'm sure, since then. Entirely new categories for creators have emerged online as podcasts and creators who share their work on video platforms like YouTube and Twitch, building audiences. But that doesn't mean that this has worked for everybody, and we've heard from people that it hasn't worked for. So the question for us now is how to adjust. We need to make sure that we protect the rights of authors and creators in order to promote the useful arts. That's what the Constitution says. And so the question is how to do that. It is absolutely appropriate to take a look at this because the entire world has changed since we drafted the DMCA. But I'm concerned that we may take action that has impacts that we don't want to have. And so let me ask you this, Ms. Rhodes, you were trying to speak for users, and I found the testimony of all the witnesses very helpful. But some have suggested that we should adjust the red flag knowledge infringement standard. I'm wondering what you think about that, and would that help, and would it have impacts or unintended consequences? What's your thought on that?
So I apologize in that is one of the components of Section 12 that I am actually not terribly familiar with.
Okay, fair enough. Let's see, who else? The library may have an opinion on that.
Sure. So first of all, I think with respect to red flag knowledge, I think the courts have interpreted it correctly. The office acknowledges that it's by changing the red flag knowledge standards as they're suggesting, it could very well require a notice and stay down, i.e. filtering of some sort. So that would move towards an EU model that really would have very serious First Amendment issues. So, this is an area where we're just, minor changes, could have, as you suggest, very serious unintended consequences. And again, the report itself acknowledges that changing the red flag knowledge standard could very well lead to, as a practical matter, of filtering requirements. And for the bigger platforms, that's not a big problem. For the smaller platforms, that could be a very serious issue, certainly for libraries. If they needed to start doing that, that would be very costly, but also it could have very serious impacts on users.
I see my time's up and I have a lot of other questions. I want to thank the Copyright Office for the work it's put in, and just note that I do think copyright modernization is going to advance the cause of compensation for artists tremendously. It's not going to solve all the problems, but it is going to be a huge help for artists and creators in getting paid for their work. And I will defer other questions to my written opportunity, and thank each and every one of the witnesses for being with us today and sharing their perspective. And I yield back.
Mr. Biggs from Arizona is recognized for 5 minutes.
I thank the chairwoman, and I'm grateful for all of the witnesses being here today. It's been very interesting, very informative. I'm going to, because we only have 5 minutes, and this is a very, in some ways, very complex topic. I'm going to approach this from the point of view of one of my favorite YouTube online creators, Rick Beato, who, Madam Chair, I would, without objection, submit for the record Mr. Beato's testimony from July 28, 2020 before the Senate Intellectual Property and Hearing, and as well as a piece entitled When the Guitar Lesson Becomes Controversial.
Without objection.
Thank you. Now, Mr. Beato is a songwriter, producer, engineer, and educator, and he's a YouTube content creator, which is why I watch him, because he does incredibly interesting theoretical breakdowns of what he calls, I think, the great songs. Maybe it's a Steely Dan song, maybe it's a Led Zeppelin song, maybe it's a Police song. Some of those songs, and he'll take a small riff and he'll define it, break it down, educate us on it. And some of the folks immediately take down his content. He's done more than 750 videos on topics ranging from music theory, ear training, improvisation, etc. But he's done almost 100 videos of what makes this song great. some of those immediately come down, and I won't name the artists, but their labels immediately pull them down. And so we're talking about creators today, and I appreciate the creators. I want to ask Ms. Rose, the Copyright Office report did not distinguish between traditional creators, such as recording artists, from purely online creators, such as those who produce content for YouTube or Facebook, such as Mr. Beato. What makes the interests of such online creators different from traditional creators with respect to Section 512?
Thank you. I actually also am a fan of Mr. Beato's, so I will commiserate there with the occasional disappearance of his videos. It's certainly, there are a number of points of difference between what we consider sort of the more traditional trajectories and traditional artists, in scare quotes, and those sort of new creators that we see emerging largely through online platforms. One is obviously the method of getting your content out to the public. Those are going to be governed by different systems. When you are a traditional recording artist, you go through, you have a record label, the publishers. Mr. Beato completely makes his own content, releases it through YouTube, and thus is entirely subject to the way in which YouTube has structured its particular implementation of things like monetization, demonetization, and notice and takedown. And at the end of the day, a lot of these new creators, Mr. Beato in particular, are really reliant on some of the provisions of fair use, which is a built-in sort of safety valve for First Amendment concerns. To alleviate some of the problems that would otherwise arise from sort of total copyright control. In his case, it's education, criticism, and commentary is the bread and butter of what he does. And what he's been facing is a good illustration of the fact that these systems, especially algorithmic ones designed in-house for specific companies to address their business needs, cannot account for those things. They fundamentally can't. They are binary systems in a lot of ways, and copyright is not a binary system. And so it's a poor match to say that really what we need to do is just sort of nerd harder and develop better algorithms, and that will somehow take care of these things, because at the end of the day, they're just not capable of doing that.
So when we look at Section 512F, and you've been critical of victims of abusive takedown notices that the provision of 512F are too weak, what would you say is a better way to beef up that for frivolous notices, while not going so far as to penalize copyright holders who issue notices in good faith, but just turn out to be wrong?
So I think the easy or the lowest hanging fruit on this is to Lenz versus Universal decided that there was a subjective knowledge standard for what constitutes good faith notice. Changing that to an objective standard would be far more enforceable at a minimum.
Okay, thank you. And real quick, Mr. Band, do you believe that government enforcement is needed? And if so, what specific types of enforcement do you think should be implemented to deter abusive takedown notices?
Yeah, thank you for the question. I think that something outside the DMCA might be needed. And so that would be something along the lines of maybe FTC enforcement or some other government agency. I think the office recognizes that even though you could tinker with 512F and maybe make it easier to bring actions, still you're talking about individuals bringing actions, and just as it's hard on the rights holders side for individuals to enforce their rights, it's hard for individuals on the user side to enforce their rights as well. So that's why you might need something, an agency like the FTC that could really, bring the weight of the government and go after these bad actors, and that would also have a pretty significant deterrent effect.
Thank you. Thank you. Yield back.
Mr. Johnson is recognized for 5 minutes.
Thank you, Madam Chair. Thank you and I thank the chairman for hosting this hearing today, and I thank the witnesses for their testimony. The IP subcommittee has spent much of this Congress exploring how to promote and protect intellectual property rights in the patent and trademark space. And today's discussion from the copyright angle has been particularly informative. Copyright law governs the work of artists and innovators, designers and developers, and other content creators. It's crucial that these creators are able to rely on copyright law protections to make their living. This is even more true in an age where the click of a button can plagiarize a lifetime of work. As chairman of the Subcommittee on Intellectual Property, Courts, and the Internet, I believe it's important that we work with the Copyright Office to ensure that the rules of the road are clear for content users, platforms, and Internet service providers. Section 512 was created before the Internet had permeated our lives, and I'm concerned that the law has failed to keep up, not adequately protecting creators and not necessarily providing clear guidance to users and others. And this needs to change. So I look forward to further hearing from the witnesses. I thank you for the very great testimony that you've already given. And we look forward to exploring how Congress can help pave the way to the future. Now, Mr. Sedlink, I understand that many online platforms have now started to require those submitting takedown notices to provide information above and beyond what Section 512 requires in order to start the takedown process. Not only does this seem to raise concerns about the extra burden imposed on rights holders beyond what Congress intended, but it implies that rights holders have to figure out how to use takedown systems that are potentially very different if they are monitoring several platforms. Can you speak to the impact that having to deal with different takedown processes is having on rights holders?
Thank you for the question. Absolutely. As a rights holder and creator, after a day of creating photographs, I am forced to search for potential infringements and to send DMCA takedown notices, of which I send 100 to 200 each week. I have no employees. So in the evenings, I go to the platforms, I find the DMCA agent information, which can take considerable time because it's often buried in the terms and conditions on these sites. And then each and every OSP has a different form that is, and all of them are manual, by the way. You have to enter your name, your address, and the other information manually, or you can send an email. I choose to send an email. I then send that email meeting every single requirement with the actual sections of the statute identified. And then 1 or 2 days later, I get in response a question such as, please explain, it's unclear why you think this use infringes on your copyright. Or please provide a URL pointing to an example of your work on the web, even though I have provided them with a copy of my work with my DMCA takedown notice. It would help to have some level of automation built into these forms, not to send DMCA takedown notices in bulk, but instead to be able to create an account and be able to save my address and phone information and be able to input just the specific information about that particular takedown and submit it. I would also say that these takedowns are not expeditious as required under the statute. I've seen it with me take up to a month or to 6 weeks. Oftentimes it does happen within 72 hours. And further, there's this exchange back and forth repeatedly asking me for information I've already provided. It would be fantastic if the OSPs could each establish a way for us to more efficiently submit these notices.
All right, got it. Thank you. Would you like to comment on that as well?
Certainly. Thanks for the question. I think there is a lot that can be done by way of improving systems. A lot of services are constantly trying to iterate on and improve their systems so that they function more expediently. It's important to recognize that a lot of platforms have entirely different interfaces. The design of the platform is asymmetrical from others. And as a result, the content isn't necessarily going to port easily from one web form to another. But that being said, the ease with which takedowns are filed in bulk is one of the reasons why we're seeing takedown rates get so high. And unfortunately, there's no penalty for submitting inaccurate or wrongful claims. And as a result, there's an industry of enforcement vendors that will take payment from rights holders to go out and send these notices, often without paying much attention to whether or not the work that they're complaining about is actually where they say it is online. And some surveys of these kinds of submissions reflect that in some cases, upwards of 80% of things that are being submitted in takedowns aren't even there in the first place. And that's important because when you have an individual artist who's trying to get content removed, their inquiry is in line behind all this other spam. And so
how often does that spam occur?
I'm sorry, the gentleman's time has expired. The chair recognizes Mr. Klein for 5 minutes.
The chair, and I want to thank our witnesses for attending today. As has been explained, when the DMCA was first passed by Congress, Section 512 was meant to preserve strong incentives for service providers and copyright owners to cooperate to detect and deal with copyright infringements that take place in the digital networked environment, while also providing greater certainty to service providers concerning their legal exposure for infringements that may occur in the course of their activities. And in the 20 years since the DMCA was first signed into law, the volume of online piracy and infringements has exploded. The study that's been 5 years in the making provides for some very interesting debate and discussion. One area that has been underutilized is 512 I-2, dealing with standard technical measures. And in the study comments, many stakeholders noted that no measures currently qualify as STMs, despite the availability of various technologies and the potential interest in consensus building across industries. So I'd like to start with a question to Mr. Sedlick. Can you just generally talk about what standard technical measures are already out there and why haven't they been more widely adopted or more measures developed?
I can speak to our standard technical measure developed by the PLUS Coalition, recently adopted by Google, previously adopted by Yahoo, adopted by Adobe many years ago. I believe that the hesitancy with regard to standard technical measures is the perception, I think an incorrect one, that they would be used to stifle fair use and to stifle free speech. The visual creators, at least, and I believe the other creators, not only want to be compensated for their use, but they also want attribution for their work as it is distributed. So the development of standard technical measures does not, under the statute, require a formal standards body. It only requires two groups of participants, the online service providers and the copyright owners, to get together and to have a discussion about how to how to use technology to support, the most important thing to me is identification of creators' works and making information available for users and machines to make an informed decision about making use of works.
Do you believe that 512I has restricted or discouraged the use of STMs? I mean, do you support the recommendations in the report that Congress may want to either broaden the language or give the Copyright Office regulatory authority to oversee the development of STMs? That seems awfully heavy-handed.
I don't know that I support regulatory authority. I do think that there needs to be a means of recognizing STMs, and that can be done through a coalition or consortium or committee of stakeholder groups that look at STMs and see if they can check the boxes in 512 as to whether or not it's open and fair and developed in a broad process, et cetera. In our process, we had 1,500 participants from 140 countries from all different stakeholder groups and individuals participating to arrive at a way to identify works. The big problem is that the OSPs are stripping out the rights information, what we call our embedded photo metadata from our works when it is distributed, and thus our works are orphaned and virally distributed with no attribution information.
Mr.
I
Schroeder, do you want to respond to that?
Certainly. So, as I was saying previously, the number of variations in systems online is almost as many as the number of online services. And so, what technology may work for a short form video service is not necessarily going to work for a text-based social media service. But as I think we've heard, there are a lot of individual companies that have implemented particular technical measures into their own either DMCA compliance or their own DMCA plus systems. Now, the fact that those might not qualify as standard technical measures because of the narrowness of the definition in the statute doesn't mean that they're not getting implemented by these different companies. It's just an indication of the fact that we don't have, with the number of variations of services online, it's somewhat more challenging to come up with a one-size-fits-all solution.
Right, but you don't agree that it requires consensus from all stakeholders across every industry. You agree that it requires only broad consensus, so that is achievable in theory, correct?
Well, I certainly think that achieving standard technical measures in a way that complies with the definition provided by the statute is feasible. The market's evolved in such a way that the participants haven't found their way to that consensus yet.
Okay, well, I look forward to the Copyright Office having additional discussions, and I think they're going to have a symposium in the near future is what they've issued in their report, so I look forward to further developments in there. Thank you, Madam Chair.
Okay, thank you. And the chair recognizes Ms. Demings for 5 minutes.
Thank you so much, Madam Chair, and thank you to all of you for being with us today. Ms. Kibbe, the chair mentioned this somewhat, but when we think about the Congress of yesterday, we could not have predicted how expansive and advanced our online ecosystem would become. We had absolutely no clue. So as today's Congress continues to examine Section 512, including whether any updates may or may not be needed, what do you believe we should keep in mind to ensure that we are future-proofing, if you will, our work in this area? It's so critical that we get it right. I'd love to hear from you.
Thank you so much. I think it's about simplifying, to be honest. The fact of the matter is that, artists such as myself, we're really just looking to get paid for unauthorized use of our works and to take down things that infringe on our artistic integrity. It's pretty basic. I mean, I'm only speaking for kind of my community that I'm in, specifically musicians that I know and artists. But I'll come back to the idea of simplification. I refuse to believe that there is not a way for us to come together as creators and service providers to not come up with, and I am not the person to perhaps come up with these questions, but to have a discussion of what are some basic questions that can be established that we check back in on that seem to me that would be viable, even 10 years from now. I think that we're at a place where we've seen how the online service providers have evolved in terms of their technology, and I think that we have to be in participation with one another to come up with some basic questions to make sure that our rights are protected, and to also make sure on the other side that creators on YouTube, for example, can continue to do what they do, because it's not like we're not in support of both types of creators, but there has to be some kind of compromise. And ultimately, I feel from my position that we seem to be, my type of creator, I can speak for musicians, like I said, we seem to be ultimately left holding the bag at the end of the day.
Thank you. Mr. Sedlick, anything you would like to add to what has been said?
Yes, and I would say that abuse of DMCA takedowns pales in comparison. Certainly there is abuse, but it pales in comparison to abuse of the fair use exception. The fair use exception is absolutely vital to copyright law, but it's not a license to steal. Go ahead and criticize my work, review it, make fun of it, teach about my work, but don't make coffee mugs and shirts and posters and iPhone cases. And, 9 out of 10 unauthorized uses, I get a response back from the user saying, this is fair use. When they're using my work on socks and T-shirts. And so education is a great first step. And the Copyright Office, I applaud them today, launched an educational website for 512 to teach the public about notices and takedowns and counter notices.
Thank you so much for that. And Ms. Carrington, my colleague, Ms. Loughran, asked about this, but I'd like to hear your answer on red flag knowledge and hear, what you believe the practice means. And if you agree that the Copyright Office conclusion that the courts have blurred the lines between actual knowledge and red flag knowledge.
Yes, thank you for that question. I completely agree with the Copyright Office's conclusion. Section 512 is written such that even in the absence of actual knowledge, red flag knowledge is supposed to trigger a duty to investigate and find the infringing material. Unfortunately, there have been a number of court cases, Viacom in the Second Circuit, UMG, Perfect 10 in the Ninth Circuit, and others that have conflated that red flag knowledge with actual knowledge in a way that essentially reads the red flag knowledge out of the statute. And what that does is it hinders the burden that Congress intended, or the balance that Congress intended. It was supposed to be a balance in which copyright owners and OSPs are cooperating to address these issues. But when OSPs are now, the courts have decided that they only need to respond when they get specific notices or when they have specific knowledge about infringement, that takes away a huge part of the statute and really goes a long way towards contributing to this unequal balance that the report documents so well.
Again, thank you all, and Madam Chair, I yield back.
Thank you. And the chair recognizes Mr. Shavit for 5 minutes.
I thank the chair for yielding. All the way back in 1789, our founding fathers included in our nation's most important governing document, the Constitution, a clause granting Congress the power to, quote, promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries, unquote. A year later, Congress did just that by passing, and President Washington signed into law the first Copyright Act. In the 230 years since its enactment, there have been millions of works registered, numerous amendments passed to improve our copyright system. The most recent significant change occurred in the Music Modernization Act, and its purpose was essentially, this was back in 2018, intended to streamline and reform how music is licensed and artists are compensated. Before that, over 20 years ago, we passed the Digital Millennium Copyright Act, or DCMA, to help protect the works of creators on the internet. Obviously, a lot has changed since then. Ms. Kibbe, let me begin with you. You've created a number of works over the years since the DCMA was enacted. How has your ability to produce new creative works and the ability of other creators like you been affected by activities needed to protect your existing works through Section 512?
Thank you for asking. Honestly, like I said in my opening statement, I just don't do it. I'm so demoralized, and I frankly don't know many other musicians in my small circle that even consider it worth doing, because they literally just pop up again. I mean, the internet is so vast that there's no human way possible to really stay on top of infringements.
Thank you very much. Some platforms like YouTube and Facebook provide automated filtering tools that are supposed to help find and block copyright infringement. And I'd ask any of the panel members who would like to address this, how effective are they? And are they adequate to protect copyrighted works on those platforms? I'd be interested to hear from anyone who might like to comment.
This is Matt Shears. I'd be happy to comment on that.
Thank you.
So these services, I think, provide a valuable additional tool to creative industries and individual artists on top of course, the DMCA compliance. As I said in my previous statement, a lot of these are both site and sometimes media specific, and they require a large investment. So expecting small startups to implement these kinds of systems isn't really practical. But that being said, within the system, these not only streamline and expedite enforcement, but they also create new opportunities for monetizing content. So in many cases, artists can say, this content which is appearing on your site belongs to me, but rather than take it down, why don't you run ads next to it? And then the artist needn't do any more, but can now claim a share of the ad revenues that are associated with with advertisements that have now been co-located next to that content. So in some ways, this is a way of making lemonade from lemons, trying to turn this infringement into a monetization opportunity that works for everyone.
Yes, I would like to also respond.
Go right ahead.
Sorry.
Yeah, go right ahead.
Sure. So I would also like to respond to that. I think the technologies that exist, such as Content ID, Rights Manager, Audible Magic, right now, in the absence of mandatory STMs per Section 512I, they're really, in a sense, trying to put a Band-Aid on a gaping wound. What really needs to happen is that these technologies, the underlying technologies, which would be completely appropriate to become STMs, should be implemented as STMs. And of course, the technology would have to be implemented in accordance with the statute, which means that they need to assist copyright owners of all sizes. And I really want to emphasize that, because there are concerns with Content ID and other similar technologies in that they are not made available consistently to both large and small content owners. And so I really want to emphasize that. But also, in addition, STMs are supposed to be developed with participation from different stakeholders. The operations need to be transparent, and again, they have to be made available to all. So, while these various technologies have assisted in some ways, there are huge gaps that need to be filled, in particular through STMs as well as voluntary measures.
Thank you, Madam Chair. My time's expired.
Okay, thank you. The chair recognizes Mr. Deutsch for 5 minutes.
Thank you, Madam Chair. After this committee embarked upon its own multi-year review of the Copyright Act to examine what's working and what is not working for creators and stakeholders, and now after the Copyright Office's thorough review of Section 512, I feel like we're in a good place to actually act on some of the recurring problems that we've seen with the current system. The basic premise of our copyright law is that we are all enriched when creators create, and they must be able to earn a fair return on their ingenuity. The core of what we're talking about today is how we can improve accountability and curb abuses of the delicate balance that the 512 notice and takedown system seeks to achieve without upsetting the whole apple cart. And as we've seen, and as the Copyright Office's report reflects, Section 512 has become a cornerstone in growth and development of the internet as we know it, both for better and for worse. And I've previously described 512 as a flawed framework. It puts all the burden of enforcement on the victims of the crime. And while this is universally unfair in theory, the system represents an insurmountable burden to small creators who cannot afford the cost of enforcing their copyright across the vast and ever-growing online platforms. Now, Ms. Kibbe, I'd like to follow up on or refer back to a conversation you had with Chairman Nadler, something you point out in your testimony, that all the hours you spend trying to track down and stop infringement of your works robs you of time spent actually creating new music or further honing your craft. And when the internet was in its infancy, that searching might have been a distraction and a frustration. But with the myriad of platforms and services, it just seems impossible. And so then, Mr. Sedlick, you go on to further describe enforcing your rights under 512 as impossible. And I agree with that. And what we have is a whole group of creators who have been effectively left out of copyright protection. I think the CASE Act was a step in the right direction here, but the 512 regime compounds existing problems. So, Mr. Sedlick, can you elaborate on some of the ways that you suggested to shift some of the weight of the burden off of small creators like yourself?
Sure. Well, one of them is to revise and clarify the knowledge requirements, recognizing that service providers have the ability to control infringing activity and deeming that willful blindness and negligent blindness are the equivalent of actual knowledge. Many of the service providers have knowledge that there are works in their systems that have identifying material embedded in the works that enable the service providers, no matter what type of platform or technology they're using, to read the information out of our visual works and to act on that information, or at least consider it or make it available to the public. That is perhaps the number one concern of creators in the visual arts, is that when we take the time to put our rights information into our works, it should not be ignored by the service providers. Google just took the right step August 26th and is making information available in all images that are in Google Images if creators take the time to put work in there. We'd like to see that across the board from all OSPs.
Great. I appreciate that. I wanted just finally to spend a minute talking about the bad actors, the repeat offenders who take advantage of the system that force creators like Ms. Kibbe and Mr. Sedlick into a perverse game of whack-a-mole, where creators have to chase down each act of infringement online, each link, each stream. And I wonder if there is anything we can do specifically on repeat infringers, the small percentage of actors in this space who represent the lion's share of the problem. Mr. Schurz, do you have thoughts on that, how to better distinguish between legitimate users and bad actors?
Well, so Section 512 already requires digital services to have and enforce a repeat infringer policy. And we've seen from the Cox case that the failure to meaningfully enforce that kind of policy can result in serious liability. Of course, there are certain constraints for anonymous users. Unless you're going to forbid anonymous use of the internet, it's difficult to meaningfully catch all repeat users, repeat infringers. But certainly we've seen courts say you need to have this policy and you need to meaningfully enforce it. So I think that's certainly happening already. And I know within industry that enforcing that policy is a critical part of their internal DMCA compliance, lest you wind up facing a massive judgment.
I appreciate that. Madam Chair, Section 512 certainly has value, but it also has flaws. We can't continue to ignore the impact that those flaws have on American creators and on our economy. And I thank the witnesses for their time and hope the committee can navigate its way to tangible solutions for the complex problems that we're discussing here today. And I yield back.
Thank you. The chair recognizes Mr. Armstrong for 5 minutes.
Thank you, Madam Chair. I want to talk a little bit about the elements of notification in Section 512C and some of the legal and practical implications. And Mr. Sedlick, you had mentioned the URL issue earlier. So if a claimant infringement requires, among other elements, identification of the material that is claimed to be infringing and informationable reasonably sufficient to permit the service provider to locate the material. And some courts have interpreted this element to require a high degree of specificity, including an exact URL for the alleged infringing material. This creates a significant burden for rights holders and contributes to the whack-a-mole problem. So, Mr. Sedlick, what kind of burden is it for an independent singer-songwriter, or anyone else for that matter, to track down each specific URL to protect their copyrighted material?
If you could only see my spreadsheets of those URLs, it is a huge burden, and the DMCA should be amended to require that upon receipt of a representative list of links to the infringing material, service providers must employ available technologies to identify and remove not only those representative examples, but all other existing infringements of a copyrighted work. And I would say that the statute says information identifying, and the work itself is by definition data, which is information identifying. So if I were to provide a copy of my work to an online service provider, there is sufficient technology available to use my work to conduct reverse image recognition and identify all copies of my work across the platform and give me the opportunity to determine which ones are licensed and which are not, and give the users the ability to claim fair use should they wish to do so.
Yeah, and the standard is information reasonably sufficient to permit the service provider to locate the material. Requiring an exact URL further shifts the burden onto the rights of shareholders and away from the service provider, who actually or theoretically controls the site and often generates revenue from that content. I don't think it's a good argument for service providers to say they can't be expected to search massive amounts of content on their site if they generate revenue from that exact same content. Your testimony suggests only requiring a representative list, URLs that would serve as examples but would require the takedown of all represented copyright work. Can you just elaborate on that a little bit?
Sure. Well, the work itself should serve as a way for the OSPs to be able to identify all copies of that work, even if they've been modified, cropped, flipped, colorized, changed in some ways, to determine where these copies exist on their systems. So the URLs aren't even needed. The work itself, if submitted to the online service provider in a similar system to what Facebook is implementing right now as a means of rights holders to submit their work, would be sufficient and should be sufficient under the statute. I think the courts have got it wrong.
Mr. Schurz and Ms. Rose, I'm going to ask you the same question. Should larger, more sophisticated service providers be able to search and filter infringing material that is reasonably identified, meaning something more general than a specific URL?
So if I may, some services already do this. I would point out that there are inherent challenges in assuming that because one iteration of a work that has been identified as infringing, that can necessarily be extrapolated to all other uses of that work on the platform. We do require the punitive rights holder to say that there's no, that they have a good faith belief that this is infringing. But how can they make that representation with respect to all potential iterations of the work that exist across the platform? We heard about the scenario with Mr. Beato earlier today, who is, I'm not personally familiar with his work, but it sounds like he's an educator who helps people understand.
And I'm just going to stop you here because that's not my question. I understand the different reiterations, but do they need do they need the specificity of the exact URL? That's the question. Or can larger providers do it in a different way?
Well, yeah. So I think it's difficult to paint all service providers with a broad brush, but in many cases, the identifying information that is provided, that is required in a particular system, does not necessarily require the URL, but the URL is sort of the least.
I have 15 seconds, and I'm sorry, Ms. Rose. I hope we can get to you later, but from an enforcement standpoint, we have done this before, not necessarily in this area, but we do it with drug analogs in the criminal system. When we first started having analogs that existed, if you change one single thing in it, then it became, then it was legal until either the DEA or the state legislation made it illegal again. And we figured out that was untenable. And while not exactly an apples to apples comparison, there are ways to do this that would make it a little less burdensome on the actual singer-songwriters. And with that, I yield back.
Thank you. The chair recognizes Mr. Swalwell for 5 minutes.
Thank you. And Mr. Armstrong, if you have another question, I'm happy to yield to you. If you want to get that in there, I was interested in your dialogue.
Yeah, I would just ask the same question to Ms. Rose. Should larger, more sophisticated service providers be able to search and filter infringing material that is reasonably identified, meaning something more general than a specific URL?
So while I can't speak to the capacities of larger platforms, and I think there's, certainly, to agree with my colleague, Mr. Peters, I think there are some that have the capacity possibly to do that and some that don't. I worry about any provision which would mandate such capacity, particularly on smaller platforms. I think we tend to fall into a trap in a lot of these situations where we have the impulse to legislate based on what Google and Facebook are capable of doing. And in doing so, create a set of rules that end up creating unfair or unreasonable expectations for smaller websites, often run by nonprofits that host user-generated content as well.
And just really quickly, and I agree with that, because what we don't want to do is create more of an incentive to create market share in the top one. Thank you, Mr. Swalwell. I yield back.
Thank you. In reclaiming my time, to follow up on Mr. Deutsch's point, Mr. Schurz, how do repeat infringer policies vary among different online service providers?
Well, so it depends very much in large part because we have a huge variety of service providers that fall under Section 512. And so the cost, for example, of terminating somebody's social media account is perhaps not as serious, at least for some users, than terminating someone's broadband access, which could, also terminate their livelihood, their ability to engage in prayer and worship and communication and so on. And so, different services take different approaches. I know some broadband providers, for example, have more extensive policies. Some digital services, quite frankly, are very strict. And so the number of instances will often vary. And whether or not a user disputes a claim against them will often be a relevant factor too. So it's not uncommon for someone to submit a takedown against a critic who says, I don't like their work. Or a competitor. My testimony has a number of examples of that. And so one doesn't want to hold against a legitimate user a so-called strike when that claim was made in bad faith. And so we'll often see policies take that into account.
Thank you. And speaking of livelihood, Ms. Kibbe, could you just, being someone in the artist community, lay out for us what it means for you financially for your livelihood if we do not have better protections for what you create?
Yes, of course. Thank you. Unfortunately, as a smaller artist, streaming is already not a huge part of my income. I mean, we can all recognize that the music industry has been completely turned on its head over the last 20 years. So I don't expect much from streaming to begin with. I mean, I think on YouTube, 1,499 streams equals $1. So it's not that much, but, I am a working class musician. So, let's say I get $100 from YouTube streams. That could make the difference between me keeping the lights on in my studio for a month or not. The frustrating thing is that the majority of us are working class musicians. We make careers out of this. We're not famous. We don't dream of buying big houses and expensive cars. We just want to do what we love. And it's kind of bleak, to be perfectly honest.
We want you to do what you love too, because we love listening to it and being entertained by it. And so I'm grateful to the chair for having this here, and I'm grateful to the panelists for participating, and I yield back.
Thank you. The chair recognizes Mr. Tiffany for 5 minutes.
Thank you, Madam Chair. I yield my time to Mr. Klein from Virginia.
Thank you. I thank my colleague, and I want to follow up on Mr. Swalwell's questions to Ms. Kibbe, because we all want you to do what you love, and we love that you're doing it. And so when you're dealing with these platforms, are you able to enter into agreements, licensing or otherwise, to be compensated for your works across the board, or are there some platforms that are more willing to enter into these agreements than others?
I would love to answer your question in an intelligent way, but unfortunately I cannot. I think as a general rule, I make the art and my management kind of takes care of the rest. So I can't speak to the specifics of each platform, unfortunately.
Okay. Are there some of the larger platforms, whether it's Facebook or Twitter, or are they cooperating with you to make sure that you're compensated for music that is put out there on their platforms?
Right. So actually, specifically with Twitter, look, in general, any company that profits from music needs to pay the creators. I think we all agree on that. Specifically, Twitter makes takedown very difficult, which adds to the frustrations that I've expressed earlier. it's not easy. And, you know, like with YouTube, for example, the video that I mentioned earlier, I sent a notice and I have to go through the whole rigmarole of justifying what is my work, not only my work, but also misrepresenting me as an artist. It's very difficult across the board, obviously with, you know, differences here and there depending on the platform, but in general, it's extremely difficult. And on top of it, I'm small enough that I will never have human interaction with anybody from any of these platforms. I'm relegated to a general algorithm generated email.
Thank you. Mr. Schroers, some of your association's members have a business model based on internet traffic, such as services supported primarily by advertising revenue. Since infringing content can drive traffic just as much, if not more, than non-infringing content, what incentives exist for such providers to do more to help copyright holders protect their works if their current efforts are enough for a Section 512 safe harbor?
So thanks for the question. I don't agree with the contention that infringing works are necessarily driving more traffic than non-infringing works. And for the vast majority of users, people want to ensure that the artists they know and love are compensated for the work that they do. And on top of that, digital services want to be regarded as valuable contributors to the creative economy. And so it leads to these, as I said, voluntary efforts that we often see where digital services try and find mechanisms whereby artists can identify the works that have been uploaded without authorization, and advertisements can be located next to those works upon identification to allow the artist to monetize some of that infringement. Those arrangements are, as I said, site specific. They're often, they vary based on what kind of media is being used. And so the ease with which that's done changes depending on the particular context. But these are the sort of opportunities that digital services are looking for to ensure that everyone can take advantage of the value of these distribution systems.
Thank you. What problems do copyright holders face, and this can be for Ms. Carrington, when a counter notice is filed to restore content that they requested be taken down, and how should the counter notice system be changed to address those problems in a fair and balanced way?
Thank you for that question. So one of the major issues that contributes to the lack of balance in Section 512 right now has to do with the notice and counter notice process. Right now, if a creator finds their work has been infringed, they're able to send a takedown notice, but the users of that work have the ability to send a counter notice, putting that work back up, and oftentimes they allege fair use in ways that are very obviously not fair use. But once that happens, once a user sends a counter notice, there are really no options left for a copyright owner. The statute basically says that they would need to then go to federal court, but most creators, especially small individual creators and small businesses, absolutely cannot afford the cost of federal court. So one option that I think would be a definite benefit in this area, and I'm very grateful to the House for having passed the CASE Act 410-6, but it would be to pass the CASE Act, which would give an alternative dispute resolution system for these kinds of issues.
Thank you.
Thank you. And the chair recognizes myself for 5 minutes. I do want to thank Chairman Nadler for holding this hearing. We've been hearing a lot in my region on the Section 512 issue, particularly from small businesses and artists who are struggling to effectively use the notice and takedown system to enforce their copyrights online. In addition to lacking the resources of larger creators or corporations, they can even be prevented from using tools that could make navigating the regime easier. And there seems like a fairness issue. Given some of the conversations we've been having in the antitrust subcommittee with some of the abuses and market takeover of larger platforms, this seems like it fits right in with that discussion. So, you know, we've heard some conversation about some of the larger platforms having developed automated systems for the detection of copyright infringement. However, often they're provided to only select rights holders, such as YouTube with Content ID, and smaller businesses and small solo creators can be locked out of those tools, forced to manually detect infringement, and that puts them obviously at an extreme disadvantage. Mr. Sedlick, your story is one I've heard from, and I'd be interested in hearing more about what you think might be potential solutions to the problem. And I'm particularly interested in the knowledge requirement in the willful disregard issue.
Well, if the OSPs have access to a copy of a protected work, whether by doing as Facebook is about to do and requesting that creators submit copies of their work so that Facebook can recognize unauthorized copies on their system, then that's a great step in the right direction. One of the most significant benefits would occur if the OSPs were to recognize and protect and maintain the rights information that we put into our works. And that includes not just on the servers of the OSPs, but they use what are called content delivery networks, which are other parties that do what's called localized caching of works. And those parties, those localized caching services and content delivery networks, strip all of the rights information out of the work to decrease the size of the work and make it load faster. If Congress can look at that and perhaps increase the scope of the protections afforded under 1202, that would be a great benefit. The stripping of our rights information is absolutely key. As soon as our work is put up onto a social media platform, it's injected into the stream of commerce. I marked one of my works as, put a special mark on it, uploaded it to Facebook as a test, and within 3 weeks, it was up on Amazon being sold as socks. It's my picture of Miles Davis, right? On socks, I bought these socks online very shortly after the specially marked version was uploaded. This is a very real issue, and my students at the Art Center College of Design are some of the best artists I've ever seen in a generation of artists that has very little chance at success in running a sustainable business or even pursuing art and making art during their lifetimes.
And I think we can assume that you did not receive any reimbursement from your purchase of those socks.
I did not, and there is no system that I know of that provides artists with compensation when their work is used, for example, on a social media platform. We're hoping to see that developed, and the visual arts community is ready, willing, and able to participate in discussions with social media platforms in particular on revenue shares for the use of our works.
Okay, thank you. I appreciate your insight here. With that, I will yield back, and the chair recognizes Mr. Raskin for 5 minutes.
Madam Chair, thank you very much. I've got a question based for Morgan Kibbe. It's based on an article that I actually read yesterday about a bunch of rock bands who've been in a fight with President Trump because he's been using their songs without their permission. And the Rolling Stones are involved, Neil Young, REM, Guns N' Roses, Elton John, Rihanna, Tom Petty and the Heartbreakers, like a dozen others whose music has been used in various Donald Trump campaign events without their permission. And they're furious about it because they say they deplore his politics and they don't want to be associated with it. So I guess my first question for you is, you've expressed very powerfully how the copyright law, at least theoretically, protects your financial interests, but will you also describe how it protects your interest in the integrity of your art and what you're trying to do with your art against dilution and distortion and corruption online?
Thank you so much for this question. It's just as important as the financial benefit of having some agency with my copyright. The video, once again, that I mentioned earlier, I dislike the imagery. It does not represent me. It has nothing to do with me. And in a world where people make snap judgments about everything across the board, day to day, for artists particularly, especially one, I don't use social media for personal purposes. It's literally only my art. I've spent years developing my voice as an artist, growing, maturing, crafting that into something that is very important to me and helps people digest, I think, who I am. So yes, that's the long answer to your question, but yes, it's just as important.
Well, and if you've got giant rock and roll bands like the Rolling Stones and Tom Petty and George Harrison's estate that are wrestling with the president about this and are caught up with lawyers and who knows how much money they're spending, is it possible for someone like you to chase down people who are essentially tarnishing your intellectual product and your artistic legacy online?
I mean, we all know the answer to that question is absolutely not. And by the way, I'm not a green musician. I've been in the music industry for 20 years. I make a good living. I'm not rich. I'm not poor. I'm like solidly down the middle. And for me, it's virtually impossible to even consider pursuing protecting myself. I have to acknowledge Mr. Sedlick. I think that, especially working with young people, and I see this. I have a couple of mentees, and I work with younger people a lot in my industry, and it really breaks my heart because it is. If it's difficult for me, imagine how it is for this next generation of artists that will not have the same opportunity to build a financial or creative foundation the way that I was able to 15 years ago. So I'm very concerned.
Thank you, Ms. Rose. The gentlelady from California mentioned the Church of Scientology as one that, as an entity that abuses the takedown orders. I'm wondering if you know anything about that and you could describe what they've done and who are the other abusers and how serious a problem is that?
So as far as the specific instances of Church of Scientology, I do not have the examples at my fingertips, but there have been several documented instances where critiques of doctrine, particularly including quotes from some of their texts, short quotes meant for the purposes of criticism or education, as well as, I believe, documentation that I believe was in Going Clear, a recent documentary about it, also faced some DMCA challenges based purely on the desire to silence.
Well, do you think it's possible to protect people like Morgan Kibbe at the same time that we prevent abuses by religions that claim that their doctrine is somehow copyrighted and protected material that can't be quoted by, I guess, former members or people criticizing the church?
I think there certainly is. I think that's something that's going to require, a lot of effort. Frankly, if we knew what it was, I think we would have probably figured it out and implemented it some time ago. But I think what we need to do is move away from the understanding that we had sort of in 1998, where the balance being set was one between established content industries and sort of a relatively nascent online tech ecosystem, and consumers were not explicitly part of that. Now we have passed the point where the ability of folks to speak and critique freely is so dependent on access to the online ecosystem that we need to make sure that consumers and everyday voices are a recognized constituency group and help build our policy around that.
Thank you very much, Congressman Raskin. Your 5 minutes are up. The next up will be Congresswoman Garcia. The plan right now is to continue to go through all of the members' questions.
I'm trying to get this unmuted. Hold on.
So that we don't stop for votes, but votes are happening right now. Congresswoman Garcia.
Thank you, Mr. Chairman, and thank you to the chairman for bringing this important bill to the table. I wanted to start with Mr. Band. Mr. Band, libraries occupy a unique space in providing public access to the internet. I can tell you that without a public library in some rural areas, and I grew up in a rural area, so every time I go home, I hear this from my sister. She's got to go from the farm into town to go to the library to be able to use the internet. The libraries still play a very important role in America. So what part of the Section 512 framework is most important to libraries being able to carry out their functions? And given their unique role, can and should libraries take extra steps to educate users about the function of copyrights to provide compensation for authors and creators?
Thank you very much for the question. The most important part of the DMCA for libraries is Section 512A. It's a safe harbor for, it's called the safe harbor for mere conduits, and so it makes sure that if you're providing sort of like broadband access, that you're shielded from liability from the for any infringing activities of your users, as long as you're not part of what they're doing. And so it is, especially given, you know, the potential for damages could be enormous. I mean, recently, Mr. Shears alluded to this case involving Cox, where it might be liable for about $1 billion in damages. So protecting libraries from that is incredibly important, and it enables libraries around the country to continue providing service for people who need it. I would just add that,
moving forward, I mean, a lot has happened since this was first enacted, right? And now we're dealing and wrestling with what changes need to be made. But moving forward and looking at the role libraries will play in the future, is there anything that we need to do today to prepare for the changing times?
Well, I think that preserving the basic framework is the most critical thing, and also to remember that, as others have said, that the internet ecosystem is incredibly diverse. You have large players, you have small players, you have for-profit, you have nonprofit, and that keeping something, the legal framework needs to be something, needs to remain relatively simple, so that that you don't have sort of a one-size-fits-all, and you don't have technological mandates, because it's again, there are so many, there's such a tension between different interests, and in particular, libraries are often also interested in representing the interests of their users, right? And the amazing thing about the internet is that it allows all of us to become artists and speakers, and allow us, all of us, to share our views and our perspectives with the world. And this is where, you know, it really intersects with the First Amendment. So
thank you. If I can, in the interest of my time, because I've got little time left, Mr. Sedlick, I had a question for you, and really, it just in simple words, 25 words or less. If I could ask every panel member, beginning with Mr. Sedlick, you know, this all sounds complicated if anybody's watching, unless they're really experts in this field. Tell me in 25 words or less why it matters to the everyday constituent in my district that we pass this bill. I mean, help me connect the dots here. Why does it matter?
To which bill are we referring?
I'm sorry, the bill that we're discussing today.
The updating the DMCA?
Yes, sir.
Well,
I mean, what does all this really mean? I mean, the changes to the Section 220. I mean, how does the average person buy into and even care what we're talking about today?
My short answer is that creators depend on having, for a limited time, the ability to benefit from their creations, and then the ownership and the access and the use passes to society. The DMCA is supposed to provide a fair means for creators to be able to create and have an incentive to create, and for OSPs to be able to have safe harbor when using creative works that are uploaded by their users.
All right, thank you very much.
Thank you,
Congresswoman, the 5 minutes is up, and I appreciate those questions.
Thank you, Mr. Chairman. I yield back.
Thank you, Congresswoman. Next will be Congressman Correa.
Thank you, Mr. Chairman. I want to thank Chairman Nadler for holding this most important hearing, and I want to thank our guests today, our witnesses, for your time and interest. You know, as we think about DMCA 1998, 22 years have gone by. You have the evolution of the internet, and I look at the internet as a distribution system, so to speak, where our small creative artists can market your products and get compensated for what you do, because at the end of the day, all of us enjoy your music, your songs. The world is much, much better off when you're doing what you do best. And so I'm going to ask Ms. Kibbe and Mr. Sedlik, do you believe that the notice and takedown system of Section 512 is robust enough to effectively handle even greater shift in the online environment? Question?
No.
Why not?
No. It's just the parameters for participating in the structure that we have. It's not working. And as we've noted earlier, there are millions of takedown notices, and yet I still see infringements on my rights popping up all the time.
Mr. Sedlik.
Yes, it is a distribution system, but it is a distribution system for infringements. 99% or more of copies of my work online are unlicensed, unauthorized uses, some being fair use, most being infringements. The DMCA gives me the opportunity to pull some of those down, but there are millions. In front of my class, when I'm demonstrating how to file a DMCA takedown notice, I'm able to find between 50 and 100 infringements in 10 minutes every semester. So this is an untenable situation for us. The DMCA is a step in the right direction, and it needs to be refined. I've provided some specific recommendations in my written testimony.
So question, very brief answer from all the panelists. Since 1998, the ability to automate and detect infringement online is improved. Some of the larger platforms have developed much automated systems to detect infringement. Is this a benefit that the solo creators and small businesses can take part? Or is this just a benefit that is really reserved for the bigger guys? Please.
I would like to answer that if I may.
Please.
Right now, most of the sort of algorithmic detection processes that are available on the market have been developed in-house by large established players. These are very complex pieces of technology. They're usually designed to be proprietary, especially in the case of YouTube's Content ID, which is sort of one of the most famous examples. It's designed very specifically for YouTube and YouTube's major content partners. So no, this is not something that is available to small businesses, small platforms, and it's also not available, frankly, to small artists. We've heard from a few other folks, my colleagues here on the panel, who have testified that this is not made available to small artists in any meaningful capacity. So any sort of private side solutions are necessarily going to reflect the priorities of the, the individuals and organizations who develop it. And that's one of the problems we have to wrangle with.
Would the ability to share this technology with the small businesses, the individual songwriters, be part of the solution?
Potentially. There's some discussion of, for those who are familiar with the patent sphere, something like a standard essential patent, where there are licensing obligations placed on this kind of technology. To license it out under fair, reasonable, and non-discriminatory terms is certainly an option. But as the market currently stands, it really just risks re-entrenching the market power of the few very, very large dominant players who have managed to develop the technology in the first place.
Solutions. Anybody? Got 30 seconds.
I would also like to jump in on that question. So I agree, automated technologies are not made available to small players, individual creators, and that is a huge problem. The scale of piracy that is on the internet today, expecting people to manually find and send takedown notices for each instance of infringement is just an unrealistic task. And it's an uphill battle that small creators just cannot surmount.
Thank you very much. I'm out of time. Mr. Chairman, I yield.
Thank you, Congressman Correa. Next up will be Congresswoman McBath for 5 minutes.
Thank you, Mr. Chair, and thank you to each and every one of you for being here to discuss our copyright laws today. And I am proud to represent Georgia's 6th District, which is home to many members of the creative community, especially people that are involved in film and music and television. I have to say, probably outside of California and New York, we have now become one of the largest environments for the creative technology and then creative uses of television and movies and music. We rely, and these creators, of course, and some like yourselves today, bring much to our lives by sharing your talents. They're sharing their talents. Movies that inform and inspire us, television shows that we watch with our loved ones, and music that we dance to through every stage of our life. We rely on graphic artists, too, when we send cards to a friend that we can't see in person, which I'm sure we're having a lot of success doing that in COVID-19. And when we wear T-shirts to express our views, and when we hire photographers to document our most special moments. Our world is so much richer because of the creative minds among us. And like I said, those of you that are with us today. We've got to make sure that our laws are serving the needs of a person such as yourselves. And this is especially important right now as we continue through a health crisis that has closed concert venues and limited the operations of music and film studios. And I believe that we can maintain the internet as a critical place for the spread of information and ideas while also making sure that our artists can actually make a living. Ms. Kibbe, your testimony resonated with me, and I did read it. It resonated with me because I have heard from many working class musicians, as you put it, from my own district. You emphasize that copyright infringement is especially damaging to musicians who are early in their careers or still thinking about whether their talent is something that they want to continue to pursue professionally. Can you elaborate on your experience working with and mentoring emerging artists and how they're thinking about these issues that we're discussing today?
Yes, thank you for the question. It's terrifying for them, if I can be completely blunt. The pandemic has just robbed us of one of the remaining viable ways to make a living. You used to be able to hop in a van, and even if it wasn't comfortable and it wasn't plush, you could tour and, make some money to get by. Now that that's not even available to large artists who are canceling multi-million-dollar tours, who employ hundreds of people, it's just so saddening talking to one of my mentees. She has to live with her mother, and she doesn't know when she's ever going to be able to move out. She's not able to participate in any active live shows, and can't even network with people now because she can't physically be around people. It's kind of a conundrum.
Well, thank you so much for that. And I'd like to move on. Mr. Seldick, I've read your testimony as well, and thank you so much for the recommendations that you made for revisioning Section 512, to make revisions to 512. The recommendations in your written testimony include prohibiting service providers from publishing creators' names, addresses, phone numbers, and emails. And you mentioned that publishing this information has led to shaming and threatening creators. Can you expand on these incidents and and the reforms that you're recommending, that you're suggesting?
Thank you for the question. So when we as creators create our works, initially we do so with the expectation that we're going to be able to benefit from them over time. The first initial use for which the work is created is only the first in a long chain of works over our lifetime of uses, over our lifetime and our heirs' lifetime of our works. And those might be very different types of uses. For example, I might create a work initially for a book, and it will later be used on T-shirts with my authorization, in magazines and newspapers, for various commercial uses. And so my ability to protect, somebody's got an open mic there. My ability to protect my work over time is absolutely essential. And well, I lost my train of thought there. So I'm gonna yield my answer.
Thank you. I yield back. Thank you for your answers.
I'm going to yield 5 minutes to myself. One of the concerns that I have heard about changing Section 512 are the barriers for entry to new businesses. Uncertainty due to changes in the law and not being able to afford litigation on copyright infringement can cause new and smaller businesses not to compete altogether. This is a question for any of the witnesses who'd like to answer. What are some of the ways that these concerns can be alleviated if Section 512 is in fact changed?
If I may, unless somebody else wants to go first.
Jump in, please.
All right. I guess what I would say is, at the outset, my testimony points out that arguably Section 512 is not the low-hanging fruit of the Copyright Act. And while we acknowledge there are problems that affect creators as well as users who are often the target of misuse that my testimony describes in greater detail, providing additional certainty and mechanisms around encouraging the promotion of creative works online is likelier to provide greater benefits in the long run. And to achieve that, we would look to modernizing the copyright system to make licensing information more available and easily accessible, to ease the speed with which a willing buyer can find a willing seller and license those works.
Any other witness would like to answer that same question?
Yes, thank you. I would also like to answer that question.
Please.
So I think it is very important that OSPs come to the table and engage in the kind of cooperation that Congress intended. And to your question about innovation and new businesses, I think it's important to remember that no one is expecting that a small OSP or a new fledgling platform is going to implement the same level of an anti-piracy program as, say, a Google. Our expectations is that the scale of an OSP's anti-piracy program is commensurate with the level of infringement and piracy on their site. So I think that is definitely not going to be a barrier to entry. It's the price to play. Creators are being hurt by piracy, and OSPs absolutely have a responsibility to do something about that.
Thank you very much. Any other witness like to answer the same question? Impact on small businesses and what can be changed to improve that?
Yeah, I would, if I may, I would just add that it's important to recognize that if this hearing were held 10 years ago, we'd be having a very different conversation. At that point, you'd be having a lot of, the large content providers, the motion picture studios and so forth, bringing their concerns and talking about how the service providers are not addressing their needs and the threats they're under. Now, because a lot of the problems of the large providers have been addressed through things like Content ID, the problem is different. It's evolved, and it's a more targeted issue. Obviously, something that we need to all find a way to come up with a solution to. But it's important to recognize that the problem has evolved. It is in many ways a much narrower problem, and in its own way, it's a harder problem to address because it is easier to sort of figure out how to work with motion picture studios and harder to figure out how to address the enormous variety of individual artists.
I thank you very much. I'll yield back the rest of my time, and now I'll turn to Congresswoman McCarcel-Powell. Congresswoman, 5 minutes.
Yeah, thank you, Mr. Chairman, and thank you for the witnesses again for coming. I represent South Florida, Florida's 26th district, and Miami is home to some of the biggest Latino creators in the industry. I wanted to shift a little bit and ask you, maybe starting with Ms. Kibbe, then Mr. Zletnik. Some people have mentioned that they would like the United States to move towards a notice and stay down approach, where OSPs have to make efforts to take down infringing material and prevent similar infringements in the future, or open themselves to liability. So do you know of other countries that have effectively implemented such a system that we should look at as a model?
I'll let Mr. Sedlick take that question.
Okay.
We have to be very careful with notice and stay down. But at the same time, we need to find a solution. When I put my work up, it comes down within a few days and then it comes right back up. And there needs to be a solution to that. I can't keep up with this whack-a-mole type of issue. And so what needs to happen is a notice and stay down procedure that does not stifle free speech and does not stifle fair use. It's important to recognize that my work itself is free speech. My photographs are free speech, and the infringement that is occurring is inhibiting and chilling my ability to exercise my right to free speech. So it's a two-way street.
Does any other witness have any information on models that have worked in other countries that we can take a look at moving forward?
Yes, so I think the closest approximation right now is the European Union implemented or passed a new copyright directive recently. The states, individual member states, are still in the process of implementing the copyright directive into their individual laws. So we actually have a very interesting situation right now where we essentially have a live sort of test run of a lot of these potential or proposed, changes to copyright law. That will take a few years for those implementations to happen, and then there will be inevitably legal challenges to various aspects of it. And so, in this case, the U.S. has the benefit of being able to kind of observe what happens in the wild as these proposals move forward over the next several years.
Thank you, Ms. Rose. And before we close down, one last question. I know that other nations have actually implemented systems that place more responsibility for negative externalities on service providers. And some advocates for service providers have argued that this inhibits innovation, and that the U.S. More relaxed system allows it to maintain its position as a leading nation in technology. Do you have any evidence that would support this?
I think, if I may, this is Matt Shears, representing a number of those industry constituents. I think the fact that the U.S. technology industry is the envy of the world and digital exports are one of our fastest growing export sectors is illustrative of the fact that we have struck the right balance, that we got it right, which is not to say that there are not problems. I think we've talked about challenges, but among all the other alternatives, this is the best path forward. And while we still have challenges to deal with, this is no one else has managed to do it better. And I note that the Copyright Office, for example, does not recommend implementing the highly controversial system that Europe is looking at. In part because they simply haven't figured out how to say, if you have a stay down obligation, if a work is taken down for an infringing use today, but it's the subject of a lawful use tomorrow, how is that how does one thread that needle? And there's no good explanation for that, at least that I've heard. And certainly I haven't seen any European member states come up with that. So I'd say, we have managed to strike the right balance.
Yeah, thank you, Mr. Shores. Look, I think that to protect people like, artists like Ms. Kibbe that have to continuously work through a system where she can't even talk to someone directly. She has to go through this process on Twitter or whatever other platform she's using. We need to find solutions, right? And I think that it's important to look at what's working in other places and what we can really study here so that we can bring that balance. So thank you to all the witnesses. I yield back my time.
Thank you very much, Congresswoman. I see no further members here to ask additional questions, so this concludes today's hearings. We thank all of our outstanding witnesses for participating. Without objection, all members of the committee have 5 legislative days to submit additional written questions for the witnesses or additional materials for the record. Without objection, this hearing is adjourned. Thank you, everybody.